get started. This special meeting of the Barry Planning Board to review the proposed changes by the, oh, she's not? Oh, she's
Oh, I'm sorry. I'm sorry, Lee. Sorry.
To review the changes being proposed by the local groups in town in response to Apex's proposed changes to the zoning. I guess we'll go through and introduce everybody first.
John DePady,
Jean Peglow,
Wesley Miller,
Tom Keeler.
Steve Harlan.
Kurt Mattis, Kurt Dudley.
We have another alternate member that's not here also. We're not here tonight to vote on any of these topics. We're only here to give the groups in town that would like to have the planning board consider their proposed changes a chance to explain themselves and explain the proposed changes that they've provided in these letters. We're not going to be making any decision tonight. We don't make the planning board, just so everybody's aware, the planning board is not the board that's going to make the final decision in reference to the zoning changes for the town, nor will it be making any decision relative to allowing windmills in the town. The planning board will only be making a recommendation to the town board, and the town board has the final decision on that. A few things that I think is important to go over before we start. Anybody wishing to speak, if you could please sign in and be respectful of the 5-minute time limit. Give your full name, legal address before speaking. Show respect to other speakers and allow them to talk without interruption. And please keep to the subject matter to one topic, and priority will be given to town residents and landowners. So again, this is a special meeting that we put together to review the proposed zoning changes. And we've heard from Apex, and we've all received a packet of their proposed changes. The town adopted wind zoning in our wind energy law that was established in 2007 or 8. And it was also supported by the recent updated comprehensive plan that was approved by the county planning board and the town board and adopted back, I think, last year, earlier this year. So, just to give you a little history of how we got here. So, let's see. There is some information that we haven't reviewed yet that's relative to ag and markets, and the ag and markets guidance on wind zoning that still needs to be considered. We did talk at our last meeting about hoping to have a decision on this recommendation to the town board by the first of the year, and that's what we're trying to keep in line with. So we have to get. Wes went through and took the letters that we received from different people in the town with the proposed changes and did a spreadsheet that kind of identifies what the key points are.
Sort of highlighted the letters this week as I was reading down through them and brought them all to the same 4 pages anyway. Some of the things were already discussed in our zoning. For the first couple pages, I've put in there where in the zoning name.
Sorry.
No, that's all right. I put that up there. Where in our zoning they're already taken into account.
So if we, I guess, I'm not sure how you want to go forward with this. If you want to go through Apex proposed changes and let them comment on them, or if you want to go through the proposed changes by the other.
Tom, we were all supposed to receive a copy of Apex's proposed changes before this meeting, and as of yet, we haven't been able to get them.
I have not received the updated version from
Okay.
Apex yet. That's why you have not
Okay,
received.
but at the town board meeting, I believe it was tabled until Apex has the final draft.
We received it on October 8th.
That was
Are
the
there
original
changes
draft.
since then?
There were some differences that the town attorney had and some revisions that had to be made. And you're not going to make any recommendations tonight in
We are
that
not.
case?
No.
Oh, okay. Just to let you know
Yep.
that that's not the final draft.
That's right.
Okay.
Carrie Richardson, East Berry Road. I just wanted to share as well that Clear Skies Above Berry will be submitting changes or suggested changes to the wind ordinance, and we will have that to you by that November 1st deadline that you set.
Okay, I failed to mention that, but the November 1st deadline was the date we set for receiving letters and other recommendations to the changes to the zoning. Okay. So Apex is still making some modifications, and can you tell us when you think you're going to
I
have
think
them?
they're done, but the back and forth was between Young Summer, Laura Bonley, and Lance Mark. And I just don't think I was CC'd on the final version, so I reached out to both of them and CC'd Lee in an email just now, so Lance should have them to you as soon as he's back.
So we can get those on the website here in the next couple of weeks or a week. Does that seem reasonable?
Yeah, as soon as I get them, I'll be done.
Okay. So I guess we'll just go through the summary of things that Wes went through. Go ahead, Wes, if you want to start that off.
Well, I went down through the letter. There was a couple letters that were sent to us. They were all the same letter, page for page. There were only 2 that were different. Some of the things that they discussed, and we need to be looking at the code or zoning to reference as well. They talked about electrical, mechanical, things that need to be in the zoning. Many of them, I think, already, or I'm sure already are in the zoning. It looks like this one letter was pretty much taken from the town of Leroy and just copied their zoning and sent us a copy of it. Without any direction on looking at our zone and saying, you know, you say this in your zoning, we want this. It'd be much simpler to look at a letter like that and do something. But anyway, they talked through here about electrical mechanical interference, shadow flicker. These are things that they're saying, you know, I guess they're saying that they want to have in our zoning, and they already are in our zoning. Total height, wind energy conversions, these are just definitions. Wind towers, wind energy systems, wind towers, they're all already in there. As far as permits, special use permits are required, they are. Set fee for a special use permit is already in there. Zoning permits required. Then they break it down and they come down and they say that, and I'm speaking as this is like the group of letters that we received. If wind energy derived tower or transmission facility is not installed and functioning within 2 years, then what they need is an alternate plan that they want them to be up and useful in 12 months or taken down, apparently. We need to have some financial assurance. Provide a performance bond. I believe that's already in there in 350-105 of our zoning. They talk about a completion bond, financial assurance. We already have things in there about forming bonds and like that, that they will be completed and up and running. And then it talks about restoration and agricultural mitigation, subsection C, restoration. This is where actual text, and did a search and it was pulled directly from Leroy's, town of Leroy's zoning. So I don't know, from this, what do you, is there anything we need to look at?
Well, going back to these changes, I guess if anybody would like to comment on these proposed modifications to our zoning, I guess.
Yeah, the ones we just discussed, and then I can go on down for the, I mean, there's things talked about location, spacing, density, structure, and like that, so.
So,
Yep.
George McKenna, when you're putting all these letters together and that, and you said that it was pretty much from Leroy thought because of the reference, the Google reference, did they have their changes in there of what it is now and what they wanted, or it was just they want to change?
They just want to change, and it wasn't very direct on, this is what you have, this is what we want, at least so far.
But there was no.
Yeah.
What?
Yep.
So you said the section from Leroy, what was that section? Is that the words that were?
The wording that I picked up on was, it says underneath electrical and transmission wires, they used the code number 165-75 agricultural mitigation subsection B construction. I Googled that and it went right to Leroy's, the town of Leroy's zoning ordinance. And then I started reading and it was just a verbatim copy, just copied and sent in a letter to us. So it looks like whoever sends it wants us to
Look at Leroy.
look at Leroy's, yeah.
If I have one more question on when you were going through definitions, I did have a question on the total height. I don't know if it's the same. In our zoning, in the definitions, it has, I can pull it up, I'm sorry. And it has the total tower height and or total height. And it has the tower height is equal to the distance from the ground to the top of the tower, not including the, and I'm probably pronouncing this wrong, the nacelle, or the rotor blades. And prior, above that says tip height is equal to the distance from the ground to the tip of the rotor blade in a full and upright vertical position. I was just wondering, why would we have total height not include the blade? Wouldn't, I mean, in my mind, just, like, it would make a lot more sense if you're talking total height, it would be from the ground to the tip of the blade, would be the total height of the turbine. So that was,
The difference between them.
yeah, and, you know, you had mentioned total height, so
You want to comment on that, Ben?
Tip height is usually discussed, right, tip height and the cell height or tower height, the two height standards, so it's unclear to me too.
So the current zoning, I believe, has 500 feet as the, is that correct?
It's the total height.
As the
Yeah, I
total
would
height.
assume that refers to tip height.
So I think that that should be corrected, because right now it goes tower height and slash or total height, where it should be tip height and slash or total height.
Okay. I'm just trying to find it.
It's on 35098.
Maybe.
Sorry, I couldn't, yeah.
340 is the way down.
That's the definition, right?
Mm-hmm. It's in, the definition.
Where's our current height requirement?
Section 103, I think.
103? So the current zoning says that the minimum height of the lowest part of the blade sweep area shall be 30 feet above the ground. The highest existing, 30 feet above the highest existing structure or within 150-foot radius of the base of the wind energy conversion unit. The total tip height for each wind energy conversion unit cannot exceed 500 feet as measured from the base of the unit to the tip of the unit's longest blade.
I think it's just a clerical, because even in, there's another section in 350-101, the application procedures and waivers, where it says, like, location of the above-ground utility lines on the site or within one radius of the total, and then in parentheses, tip height. I think that it just literally, that and/or total just needs to be moved up to the tip height, because it seems like that would be more consistent with what's below it.
It explains it down below.
Right, I mean, it even defines it in the,
Yeah.
later on.
Okay. Was there some definition change that wanted to be inserted for the 305 101A about electromagnetical interference?
Wait, what-
No, I think that, I made that note because that was actually defined down in, it was not in the definition, but it was talked about it in 305-101A, 8E. About electrical mechanical interference.
Okay. topics that was brought up before too was the section 340-105D, which talks about the decommissioning and the period of time that the tower has to be, not be used before it should be removed. And Apex has proposed, what was their proposal on that? That was 105D.
Six months.
Yeah. And so they're proposing 6 months, and the others are proposing 2 years, is that correct?
Yeah, the letter from, that you sent a copy of.
With that,
Oh, you're looking at?
yeah.
Okay.
There's another one too.
No, not this one,
Oh.
the letter from, one of the letters that was sent to us.
Okay.
So we were looking at it. Under permits.
350-105. So yeah, if it's not used within 6 months, I didn't look in our zoning, but I found it in Apex's.
Mhm.
So the way it's suggested to us to be modified by legal counsel is that if Apex wants to drop the word unused under the new paragraph F, it would seem that if a turbine is unused for 6 months, whether decommissioned or not, it should be removed. Is that consistent with the change that you're proposing?
Sorry, I don't understand the question. Can you say it again?
Well, the current decommissioning we have in our current zoning calls out for 180 days. But you have to remove the unit. Let me get the thing here.
Yeah, I think last meeting we went back and forth about the term unused because there's a number of reasons why a turbine might be curtailed, either by off-takers or as a condition of our Article 10 permit. So the word unused was ambiguous. I think we talked about the difference between something being curtailed or inoperable or unfunctioning and so.
If it's, I guess if it's unused or not for a period of 6 months, would that be termed as decommissioned? If it's not used for 6 months, would it be considered to be decommissioned and have to be removed?
Well, again, I think that we were going back and forth about the word unused. So if it was like inoperable or, damaged or if it was something that was well within our control to fix, for 6 months, and that's what we're talking about. If it was, say, curtailed because the transmission grid, which we don't own or operate, was being repaired, you know, that's beyond our control, so we'd ask for that to be considered in the law.
How would the town know about that?
About,
How would they be educated on those types of things?
I believe,
In other words, what would be the process of informing the town as to how, what the reason is for it not being
yeah,
run?
I think that Lance asked us to include a clause that would require us to report a down turbine, for lack of a better term, in its cause. So, not sure if that's in the version you have there or not.
Does that come under issuance and special, reissuance and special use permit?
Yeah, I don't think there's gonna be a special use permit for each tower. There's gonna be one for
Right. The group, yeah.
the group.
Sorry. So I just have a question on that as far as, when Ben was, he just referenced like Article 10 or being curtailed by, not being able to put it into the grid. 6 months is half a year. And if each of these turbines is supposed to be producing electricity and supposed to be benefiting New York State and benefiting our efforts to become an environmentally sustainable state, why, to say that for 6 months, and that's half a year, if a turbine is down for whatever reason, and it does say that the town board can provide further extensions in a time for which, you know, they can explain what's going on. I guess I don't understand why that would need to be extended or changed.
But,
Well, I think the current standard is 2 months, right? We just felt that that was unreasonably burdensome, and that we would, you know, that it takes 2 months sometimes to ship turbine parts across the country, and that 6 months was conducive to operating the plant. So,
But I think that's what the extension is for.
extension.
So
Yeah,
it
for
says-
6 months, right?
No,
It says that it can go, unless such time limit is extended by the town board for good cause shown, but the total period shall not exceed 6 months. Or 180 days.
Yeah. I think we're agreeing to the same thing, 6 months unless extended, right?
So,
No, 2 months, and then you get an extension up to 180 days.
No, I think Apex felt that 6 months was more appropriate.
George?
So I'm confused. They're asking, I mean, the zoning says now 2 months. If it's down, not working for 2 months, you know, they need to have it fixed by then, unless they ask for extension, which they can get an extension up to 6 months. Is that what the zoning says? What is this person or letter, conglomeration of letters asking for?
This one actually said in the permit requirements, expiration, a permit issued pursuant to zoning ordinance expires if wind energy conversion system or wind energy deriving tower and transmission facility is not installed and functioning within 2 years from the date of the permit is issued, or wind energy conversion system or wind energy deriving towers and transmission facilities is out of service or otherwise unused for a continuous 12-month period.
So they're asking for
An
the
additional-
whole permit to be taken away, or that's not just, I'm sorry, I'm just not following. They're asking for.
It says wind energy deriving tower and transmission facility. It sounds like it's, I would say, for a tower.
Sounds like we have that covered already.
Yeah, ours is tighter than what they're asking for, at least in this. But,
Yeah, so it's confusing.
Yeah, we got 180 days. Can't be more than 180 days.
I wonder just, I feel like maybe when you reread it, that maybe they were referencing the entire project and just, because it seems like up and running, like the project, you know what I mean, that they don't want construction to go for longer than 2 years. I don't think, in my review, I don't think we have anything in our ordinances that have like a set timeline like that
For construction.
for the construction of the proposed facility.
So we agree that the current zoning has 6 months, the proposed changes by the residents is 2 years, and Apex wants to leave it the same, they want to leave it 6 months.
We would accept a longer window to fix our turbine if we needed to. We had actually originally proposed 2 years, and then we agreed to move it back to 6 months during the last meeting, I believe. Okay. Here.
Yeah.
So, this is a point of contention between the two proposals.
The other thing that, since we're talking about that section, would be the lien, decommissioning lien. And we had a discussion about this last time about whether or not the lien would be applicable to the tower, the owner of the tower, or whether it would be applicable to the owner of the land. And I don't know if that was ever clarified, but it was a good question.
I think the decommissioning bond that would pay for decommissioning is what we're talking about, right?
Yeah,
That is meant to cover the entire project, so not just the tower. And Casadega's Article 10 certificate specified that the note would be held by the town, so that the town would have the bond, be able to recall the bond in the event that the project had to be decommissioned without impacts of the owner.
the question was though whether or not if a tower was, if the project was abandoned and a lien would be placed on the funds the tower would be generating. Is that correct?
How would it generate?
Well, not generating, but if you were a property owner which had a tower on your land, would the lien be on your property because it has the tower, or is it not physically on the tower?
I don't know the answer to that.
I'm not an expert in this, but I will share that there was an Apex project in the Midwest, and there was, I shared at a previous town board meeting, where it was a mechanics lien that was placed on, the lien was placed on the landowners. Now, I was told by Heritage Wind that mechanic liens are very common in construction, and that it wasn't a big deal. From the articles that I read, it did seem like it was a big deal for those landowners, but that was on, the mechanics lien was on the landowners, and they listed the names of the landowners. And I believe that was based on the contract, or the lease that was signed.
Okay. So we gotta find out more about that. Is there any way you could find out more about that?
Sure.
And we'll get with Lance on that too. Okay.
Yeah, we were just gonna look into that last week.
Was that brought up at the town board meeting?
Pardon?
Was that brought up at the town board meeting, Sean?
About what?
About the lien?
Just to let you know, Lance isn't coming tonight, obviously. He said that any notes and so on, please forward them, and, Clear Skies, he'd like to take a look at that. He will be at the next planning board meeting then.
Okay. Okay. Any, you have another topic you want to move on that?
Okay. Now, there is a section, they talked about proximity to transmission lines, number of wind turbines in a location, nature of land use and adjacent and nearby properties, surrounding topography, proximity to residential structures, design characteristics to reduce and eliminate visual obstructions, possible adverse effects on migratory birds, possible stray voltage, impacts on orderly development, property values, aesthetic conditions, and NYSERDA, it has to be NYSERDA certification at that point. Is there anything in there we can put in our zoning, or is that DEC regulated, state regulated?
That's probably gonna be Article 10.
So you listed a number of different things there, a number of different agencies that oversee those items.
And then, as far as locations, they go into locations, no tower located within a quarter mile of state forest, public park, or any other area designated for preserving unique wildlife habitat, natural formation recognized by state, federal, local government, or within 1,000 feet of state identified wetlands. No tower located within 2,500 feet of important bird areas as identified by the Audubon, New York. Anything?
Yeah, if you wanna just go over the current.
Yep.
So what's the, I guess the question is, what's the current setback from a state or federal wetland we have in the zoning now? You know what that is offhand, Ben?
I believe the current wind ordinance on the books discusses setbacks to wetlands, from my memory, but wetland delineation is a required part of Article 10. DEC and U.S. Fish and Wildlife Service are going to be involved in reviewing those delineations and are going to be doing some of the delineations. I should say they will review some of our delineations by hand themselves. So there's already a procedure in place to evaluate those. My understanding is that there's two sets of wetlands, right, federal and state. Largely they cover the same areas, but not entirely. So impact is regulated, impact of those wetlands is like regulated by those agencies pretty strictly. And I couldn't tell you if there's like a specific setback, but I know for a fact there's a 1,000-foot setback required for wetlands in New York State. Generally, I think the requirement is not to impact them. Right? And if we do, there's a certain requirement for mitigation or rehabilitation where they cross the wetlands.
So there's no footage, as far as setback.
To stay as far back as 1,000 feet or something like that. And I want to say that DEC maybe a setback for the areas off the top of my head.
Nothing,
I haven't looked at myself.
yeah, there's something to look up then, because I'd like to know.
Yeah,
I have wetlands.
yeah, it's well known, so.
Important bird areas, can I comment?
Yeah.
Would that include migratory routes for endangered species?
I'm not sure what this proposal contemplates, but U.S. Fish and Wildlife and the DEC are also very involved in evaluating our bird studies, and there have been 2 years breeding bird, migratory bird, eagle raptor use surveys completed, and those reports on those studies that have been published are published on our website in our preliminary scope and statement.
May I comment?
But I'm wondering, is there another zoning out there that tackles that question?
I have a letter here from U.S. Fish and Wildlife that indicates that Apex's studies overall are inconclusive and sometimes even incorrect in the way they've conducted their studies. And they called them out on a couple occasions in this document. If you'd like to have it to look at, I can give it to you.
Yeah.
Okay.
In reference to that, I would encourage all of you to look at the preliminary scoping statement, the bird study that was included in that, as where they were looking at the results. 4 of they had like stop where they stopped and actually looked out and spent half an hour in one location. Majority of those locations were actually in the airport zone where they can't place turbines. And that was cited because that was the only area that had the or those are the areas for the habitat for those birds. But we know Westbury and Eastbury aren't really that different as far as the bird population. And so I think that just looking at the study, it may seem a little more skewed than we would like to see.
Also, just to rehash part of the conversation from last time, is that we're making this proposal because these items and the details of both proposals are going to be litigated, right, through the Article 10 process between the state agencies, us, the applicant, and the citizens groups, including Rochester Birding Group. Check in Article 10, and there will be, I assume, just like a cascade of conditions to our certificate, which speak to these details. So the goal of Apex submitting this proposal is to align the town's law with what we expect to see in that process. So that's how we get here, with the context that this is all going to be thoroughly litigated by state agencies responsible for these issues.
And I just would like to reference that the state agencies have stated that they are not a police state. They are not going to just try and, if the Article 10 is not going to just go through and say our zoning does not matter. It will say our zoning will matter. They do have a clause in there that if it's unreasonably burdensome to the developer, that the state could step in and usurp that. But in talking with James Dunn at the Department of Public Service, he has stated that they are not trying to go through and change our ordinances. So if we know our local area and our population, and if our zoning is different than what is decided by the Article 10, that our zoning is supposed to take precedence.
I have 2 documents here. One of them is the newest bird study that's out there concerning bird species that have been attacked by turbines. And then this is also the article from Fish and Wildlife. But I need copies. I gotta have a copy of that.
Okay.
That's my last copy.
setback, I wanted to go over the setback a little bit, and what you're proposing changes, what proposed changes Apex is bringing forward for the setback, and then what the other letter we received has. The current setback. You know what that is? Where that is with you? Let's see. We got that here
The current zone discusses a number of different setbacks.
for you. What's the section on that?
103
103.
standards.
35103,
Yep.
number 8.
8.
Mhm.
Okay. 35138. Okay. So the wind energy conversion units shall only be located, installed, or constructed on the subject parcel in accordance with the following setbacks. A distance not less than 1.5 times the tip height of the energy generating unit as measured from all public roadways or above-ground power lines in the vicinity of the said unit to the base of the unit. So the proposal we received from the residents suggests that the setback should be 6 times the total, should be half a mile or 6 times the total height. So that would be 3,600 feet. And the current zoning we have is recommended to be 750 feet if we had 500 feet tip height. So there's a significant change there. Any comments on that?
Just so you know, some of these are already written into town laws in other parts of the state of New York, just so you guys know that. It's not something that's unusual in New York.
I will share, we are in agreement in a greater setback distance, and when we propose our wind ordinance changes, we will have specific scientific reasons and purposes and additional information as to why we feel that that setback is necessary.
Nancy Blank, East Berry Road. I have a question about setbacks. Now, is this setback from property lines or from buildings? Or where is it from? Because it's the job of the town to protect and our welfare and health. So if you're a non-participant, shouldn't it be to property lines so that it doesn't overlap with, onto non-participants' property?
Well, the one that we just spoke about was relative to public right-of-ways and public roadways. The other piece of it is the distance to participating property lines. In the current zoning, it says that a distance of not less than 1.5 times the tip height, which in this case currently is 750 feet, of the wind energy generating unit as measured from the property line to the parcel on which the said unit is to be sited. So we only have a setback currently that talks about a setback from the piece of property that the tower's on. And one of the proposed, correct me if I'm wrong, but one of the proposed changes that's being considered by, the Apex is proposing includes adjacent properties which also have a wind lease. So that's one of the things that has yet to be discussed.
There was an addition of that too, 1,500 feet from existing residential buildings. Was also discussed at the meeting, last meeting. No.
So the proposal that you guys are have in front of the board is one that would allow a setback distance of 1.5 times the tip height, and it's from any leased property.
Well, from non-participating property.
From non-participating.
Yeah, so we proposed to include that the same clause, keeping the same 1.5 times tip height standard, contemplate that adjacent landowners or adjacent parcels may be owned by the same landowner, or a landowner who's agreed in contract with us through a lease to allow for a turbine to be sited on the other side of the property boundary.
And the proposal we have from the group, I'll call it,
Oh, that's not ours.
No, I know,
We
but-
haven't proposed ours yet.
from the other group is such that they're proposing 6 times the total tip height, which would be 3,000 feet. So we're talking about 750 feet or 3,000 feet. That's the difference
That's assuming they're 500.
at 500, yeah.
Which
And
isn't enough wind to substantiate here.
I was just gonna say, and I will keep it brief because I would like to get into that a lot more when we actually present ours, but not knowing the height of the proposed turbines, maybe looking at multiplying the height rather than setting, a minimum and then based on height, because if you don't know the height, it's hard to protect the citizens or kind of figure out what's gonna be the best moving forward. And the other thing is just that it's to protect all citizens and adjacent land leaseholders and all that, just protecting everyone,
Protecting them also.
yeah.
Well, this one says the greater of, just so you know, the greater of a 1/2 mile or 6 times.
Right, so it's like the minimum would
So
be
you know
half
your
a mile.
minimum's a 1/2 mile.
Yeah, yeah, so,
And we think we're being quite generous with that in that, in most cases, to be unaffected by any of these monoliths is most people find that if they're a mile away or further, they're in most part unaffected. So I think our suggestion is somewhere in the middle of the road, and I don't think it's unfair to ask for that at least. We're trying to save property values and people's health and a whole lot of, you know what I mean, and a lot of our habitat out here. I mean, there's a lot of reasons why we've done this.
The current zoning has not less than 1,000 feet from any existing residential or commercial building. And the group's proposal talks about, again, 6 times the total height, which is 3,000 feet.
I just think that they're including the organization in this.
Yeah,
Just
I
the way
mean,
they're coming up.
you discussed 1,500 feet, didn't you?
Yeah, we agree with that. Yeah, we did change that in the revisions made with Lance. The property boundary setback that was applied at Casadega was actually 1.1 times tip height, I believe, to the existing parcels, so kind of varies as far as being restricted from that. And to the point John made about public health, Department of Health sits on the state siting board, which will review application and mitigate our application. So again, we're just trying to align the standards discussed in your ordinance with what we expect to be applied in that process. If there's specific information.
Just to give you an example of what can happen with these turbines is, and I can get you the guy's name and address. He was 1 mile away from a wind farm, and the vibration in the ground cracked his foundation in his house. The wind company tried to get him to sign a non-disclosure form and not publish it, but he refused, but they did, and he came out with it, but he also was compensated for the damage to his house. So that's a mile, I believe that was a mile away. So it depends a lot on the geology, and I don't even know today if there's been any geological studies done in East Barre, to be honest with you. These pilings, they'll say the footers go down 5 feet, but the pilings go down how far? They can go down as far as 50 feet, correct? The pilings? 50 feet, is that it? That the average in the wind industry?
It depends on the.
That's a long way, and there's a lot of wells out
Yeah,
there.
let's move on. Let's move on.
Point taken.
Thank you.
So the setback is one of the big topics that's gotta be modified if it's gonna be modified or it's gonna be increased, so. George?
I guess also needs to be taken in consideration with the setbacks is we're all thinking of one setback for 1,500 feet in that, but you also have to take cumulative effect of, two, in that same area. That's what I'm gonna say.
And the developer has stated that there is an aggregate effect. So like when you have, my residence proposed right now is five turbines within 1 mile, and that will cause an aggregate effect.
We currently have shadow flicker in our zoning under section 350-103J. And it talks about in the current zoning that we have 25 hours per year listed, and Apex proposal is to increase that to 30. Correct?
That's correct.
And that would be measured on any non-participating residence or business.
Yeah, we
Right.
call it sensitive, introduce the term sensitive receptor. Yeah. Which, I think, just to read that, sensitive receptor includes non-participating residences, hospitals, care centers, schools, libraries, places of worship, cemeteries, public campsites, summer camps, public parks, and New York State lands. That's the definition that comes from the Casadega decision. It's a little bit more broad than homes and businesses.
So it's measured and gonna be calculated on 25 hours a year right now, and they're proposing 30, so. Any comments on that?
Do you want me to continue commenting, or would you prefer that I just wait until
Well, it sounds like a lot of the things you're gonna propose are similar to this, is that correct?
A lot of it, we have setback and noise are our two biggest concerns, and I will have specific information. Those are the two things that we really feel that need to be changed to protect the citizens of Berry. Shadow flicker, we had a 2-scale map, I don't know if some of you may have saw it at the Orleans County Fair, as best we could with the information that was provided. And the shadow, when the sun went down, we turned the map so it was properly oriented north. The shadows were over a mile long. And I would like to stress it doesn't matter if you're a leaseholder or not. If there's a limit in our zoning for flicker, whether it be 25 hours or 30 hours, they should be considered too. Just because they signed the lease, no one in the town of Berry knows what flicker is in their home. They don't, you know what I mean? Like, you can go somewhere and see it, and I don't know how many of them, but if this is to protect all residents of Berry, it should be across the board, whether you're a lease signer or not. Whatever the limit is that's decided upon, that should be just across the board. That residents of Berry should not have to deal with more than 25 hours a year of flicker. I don't think that it should be separated.
If I can add to that, you can find examples of shadow flicker all over the internet from the complaints from people who are complaining about the shadow flicker in their homes. There's lots of video.
I just thought of something when you were saying about sensitive receptor areas and that, and, wanting to do it the 30th. Hopefully, the sighting is smart enough, but worst case scenario I can see is shadow flicker at a church during service, but it's not gonna be 30 hours a year. But it sure would make a difference on that church or a business or, what we're looking at. So that's kind of important.
And we don't have anything currently that identifies,
Where these are gonna be located.
and we don't have anything that identifies how it's measured. It's measured only on participating properties, right? Or non-participating properties. So that could be a church, could be a residence, could be a business. And Apex did tell us at the last meeting that you're willing to adjust the turbine moving or not moving to compensate not to get above that limit, is that correct?
Yeah, that would be the correction, would be to curtail in excess, if there was gonna be shadow flicker in excess of 30 hours per year, that we would curtail, if we reach 30 hours during the times where shadow flicker would occur. I think it would also benefit everybody here to take a look at the Casadega proposal or application, which lays out a calendar of shadow flicker impact projected on each sensitive receptor in the project area per year. So, just as we can predict when an eclipse will be visible from any point in the U.S., we can predict shadow flicker and when it would be likely to occur. So that would all be included in our application.
And that's a comment that I made last time, is the technology, computerized technology available there that when you can predict that, it could be shut down, so it would be inside. You guys are saying that's not this. Good, exists.
Yep.
Hi, Nancy Blank. I'd like to ask a 2-point question. First to Ben, why do you want to increase it 5 hours? And part 2, why would the town board want to increase it rather than keep it the same or even make it less for the town, for the welfare and health of the town? I mean, it's a negative thing, so that's my 2-point question.
Yeah, happy to answer your question, Nancy, although it's the board's meeting. The reason that we propose this is because these are the standards we expect to be held to in the state's review process. And so for the same reason, we would ask the board to include them in their ordinance, as that will be that's the expected result of, the application process, which the town is going to be involved in as a party to the project. So, as I said before, this whole proposal is Apex's best effort to address these issues jointly with the town before we get to that point, rather than expecting the state to override local zoning, which, as Carrie said, nobody can really expect them to do. That's why we ask you to adjust your standards accordingly.
So am I figuring it correct when you're saying 30 hours per year? If I'm dividing 12 into the 30, that's a little over 2 hours per month.
Yeah, on average, across the year, sure, but, I mean, the days are longer in the summer than they are in the winter, right? So, that's why that calendar becomes important, wrapping your head around how those hours are distributed across the year. I believe the Casadega conditions also discuss like a maximum monthly amount of shadow flicker. So it's like a second shadow flicker standard.
I would just like to comment that, yes, he's right, it will be litigated and we'll go through that whole process, but the people who are sitting in those meetings and talking and making the DEC and individuals from DEC and Department of Health and all those, it's not their homes that they're talking about, it's not their neighbors' homes that they're talking about, and I think that it's still really vital that our planning board and that our town board are looking at, in my mind, if the capability is there that you could have these structures and have zero shadow flicker because you can turn it off, and, if they're saying that 25, I mean, that's not that much, why not just bring it down to zero for the citizens? We don't have to just go with what, we don't just have to accept, what happened in Casadega or other projects. This is our community, this is, the decision is in your hands on this. And if the technology is there and that to, better serve the residents of Berry, why not?
Are you familiar with other projects that Apex has in the country that possibly have shadow flicker hour restrictions that are less than 25, like our current zoning?
Outside of New York, I'm not familiar with those details. I could look into it for you, though.
I'm just curious whether they have that.
I'd have to ask around. No, in fact, the only other Apex project in New York to get to the application stage is Galoo, and it's on an island, so standards are a little bit different. And as Carrie said, it's a different town.
Are you familiar with what Yates's, what the current zoning is there?
I don't, I'm actually not familiar with it. I understand it's very restricted, though.
I'm just curious.
I can tell you in just a minute.
I don't really know how 25 hours was established in our zoning in the first place. I mean,
Yeah.
they must have used some history to get to that point. In 2007 or 2008, there weren't very many wind projects around.
It'd be a helpful point of reference if we had notes from how this zoning ordinance came to be, but many times, I'm sure one town takes it from the next town to the next town. So I think Lance's office drafted it, so perhaps there's some notes there that I've never seen.
So Yates has, I believe this is Yates, they have a 30-minute on the worst affected day, a 30-minute maximum. And that's on no off-site residents. So it's not just for public building, I'm forgetting the term that was used, but that's for no off-site residential experience based on an astronomic worst-case scenario more than, and they actually have 30 hours per year or 30 minutes on the worst affected day.
I think what the wording you're looking, it was non-participant?
No, because it was like churches or parks or sensitive receptors.
Sensitive
Sorry, sensitive receptors, that was the.
Well, the other big issue, other than setback and shadow flicker, is the noise issue. And you're proposing some changes to that also. And that's in 350, 103B of our zoning. And the current zoning says that the level of noise produced by or from an operation of the wind energy conversion system shall not exceed 45 decibels. Which means that 45 decibels may statically be exceeded only 10% of the time, 6 minutes of every hour, measured at a distance of 1,000 feet. And then during any allowed period, the sound level exceedance is set forth, the noise level shall not exceed 51. So the limits you guys, or that we currently have, are 45 and 51. And the proposal that Apex has talks about 45 decibels and then 55 for any specific time. Is that right, Ben?
Well, yes and no. The current ordinance, or we should read this carefully, I thought reference to DVA L90 max, which is, it's an important distinction, right, when we're talking about decibel levels. The term, how that is measured over time, or averaged, is either, restrictive or less restrictive, right? So like an L90, this is beyond my technical expertise, but L90, I believe, measures the 90th, right, like the 90th percentile of sound, which is an L10, which is the 10, like the lowest 10%. I'm looking at, better here. Anyways, there are 6 standards of measurement attached to Cassadaga certificate, which ultimately is what we discussed with Lance at the last meeting, and to amend our proposal, as well as a 7th condition that says that, I'll read it right here, that if these standards shall apply unless a more restrictive standard is adopted by the board on electric generating siting, so the siting board. So there's quite a bit of technical detail that needs to be sussed out here in order to fully understand it. Probably more than I can realistically offer you tonight, but I'm happy to provide access to our sound tech and answer written questions in detail if you have them.
Yes.
Nancy Blank, I'd like to make a comment about that. I just read that the World Health Organization yesterday says that anything above 40 decibels causes adverse reactions to humans, and I imagine mammals of all.
See, that's a sweeping statement. We're speaking now at over 40 decibels. So, also, just want to point out that the standards that we're discussing, 45 decibels, would be to the outside of the home, and are not far above, if at all, above ambient noise levels, existing ambient noise levels in the town of Berry. Our application will include the results of 2 seasonal ambient noise studies to help us describe the noise effects proposed by the project, the new design. So these are important details to consider.
Ben, can you ask him a question? Can you describe infrasound and the effects on the human body?
Do my best. I understand infrasound is defined typically as low frequency sound, right? That's what we're talking about?
That's part of it. Yeah.
Um,
Have you done studies to see how that affects the human body?
Well, part of the Article 10 process will be,
Well, I'm asking you, according to your
allow me to
knowledge,
answer your question now.
have you studied it? Have you looked-
Have we studied it?
Yes, have you looked at it personally?
We don't, no, we haven't been.
You haven't looked at it
Studying
at all
infrasound
yourself?
effects on humans.
I'm just, trying to discover the humanity there.
Shouldn't questions be addressed to the board?
Okay, well, it's
Go ahead.
infrasound that affects most people, and it can cause everything from heart problems to hearing problems to balance issues, and the list is quite long.
Yeah.
And
Is it
I
a question or a statement, John?
pardon? No, this is scientific evidence.
Speak.
Hundreds and hundreds of doctors' reports globally describing the effects of the infrasound on the human body. Easy enough to find on the internet. A good place to go and study first is the UK, because that's where they came first about 40 years ago, the turbines. Germany's another place. The information's out there. The World Health Organization is also aware of the problems that they cause.
Okay.
It's absolutely no secret now
Thanks, Jim.
that they do cause problems.
Okay.
George?
Just for clarification for myself, and for the 45 decibel that we're referring to, at the people's home, is that an average over time, or is that?
The current zoning says that the level of noise produced by or from the operation of a wind energy conversion system shall not exceed 45 decibels, which means the 45 decibels may statically be exceeded only 10% of the time, 6 minutes of every hour.
So,
So 10% of the time,
So that's what L90 means.
6 minutes of every hour.
Right, so 45 dBA L90 is a very different measurement than 45 dBA L10 or dBA LEQ.
This is DBA 10, L10 we're talking about here in our current zoning.
I think 103B2 says L90.
Yeah, well, I'm looking at 102,
Uh,
or 103B1 right now, but.
No, that it may be exceeded only 10% of the time, I believe is the definition of L90. But again, this is there's a entire field of physics around measuring sound, and would be happy again to provide you with access to our sound tech. The town, the citizens groups received intervenor funds to do their own studies relative to the project. You could also use those funds to better understand this. If there's, if you'd like us to provide our technical explanation of these standards, I think that would be helpful.
It does also say here, if you keep reading, shall not exceed 45 decibels, measured at a distance of 1,000 feet from the base of the wind energy conversion unit, or that portion of the wind energy conversion system causing the noise level that is in violation of these requirements. So it's 1,000 feet. So if your residence is further than 1,000 feet, I don't know what noise levels are, but this is saying 1,000 feet from the base of the wind energy.
The speed of the turbine blades is gonna change the output of noise. You have to remember that as well. The faster they turn, the more noise they generate.
and that's what I'm wondering about the average. I mean, if it's really turning fast and it's putting out a lot of decibels, but then it sits and doesn't do anything for 3 hours, the average might be pretty low. But during that operational period, it may be very disturbing.
It said, it also goes on to say during any allowed period of sound level
Exceedance.
exceedance, the noise level shall not exceed 51. So it can't be any louder than 51 at 1,000 feet.
At any one time.
Yeah.
Mhm.
Now, you're proposing a change to that, though, right, Ben?
Read through this real quick. I'm not sure that an L-max is discussed in the Cascadia conditions. Don't believe so.
He's also, Apex is also proposing a limit of 50 decibels. Take his,
Maybe good. Yeah, D.
Yeah.
You're looking at letter B.
B, yeah, B1B.
That was, so the condition applied at Casadega was limited 50 dBA at night outside, right? That condition, we don't expect to be applied in future decisions by siting boards, but we included it here because our agreement from the last meeting was to apply the Casadega decision. No proposals?
So you're saying the siting board wouldn't put that in there at all?
We don't expect them to.
Just if you're curious, Yates says 40 decibels.
Max?
Noise, except during short-term events, including utility outages and severe windstorms. No, I'm sorry, this is so small. My apologies, I was looking for wrong.
Yeah, I was reading further, we got
Yeah.
C, D, E.
yeah. D.
Are you interested in Yates? I have the right one now. It's actually like a table, but it says, the equivalent level generated by a wind energy conversion system shall not exceed the limits listed in Table 1 when measured at the nearest off-site residence existing at the time of application, or for which a building permit has been issued. If the A-weighted background sound pressure level without the WECs is within 5 decibels of some or all the limits in Table 1, or exceeds some or all the limits in Table 1, then the A-weighted criterion to be applied to the WEC's application for those affected limits shall be the A-weighted background level of plus 5 decibels. Note, for example, during daytime, if the background is less than or equal to 40 decibels, then the limit is 45 decibels. However, if the background is greater than 40 decibels, say 44 decibels, then the applicable WECS limit is a background level plus 5 decibels, which calculates to 49 decibels for this example. So Table 1 has noise limits at residential receivers, 1 hour derived per ANSI. A weighted level is daytime 7 AM to 8 PM 45, and nighttime 8 PM to 7 AM 40. And then WEC's noise limits, this is table 2, at non-participating property lines and other district boundaries. 1 hour drive per ANSI. A weighted level, daytime is 50 from 7 AM to 8 PM, and nighttime 8 PM to 7 AM is 40. A weighted background community noise level shall be based, if there's a lot, I'm gonna stop there. But it gives you an idea.
This does also say,
Yeah, the noise is pretty confusing.
Yeah, I mean, that's why there's so many different conditions applied here.
Right.
You know, each one would be, like I said before, you know, litigated between the siting board, of whom the Department of Health is a member, and then the citizen groups in the town itself. You know, if Apex were to propose this again, I would recommend that we just include the last letter here, that we align this town's noise standards with the results of that litigation. But, you know, respecting that, as Gary said, that the town wants to have a law on the books that speaks to this, the Casadega decision is the case study. You know, it is the most recent thoroughly litigated case on this issue, so that's where we get the conditions.
Do we have the fact on what the height of the towers is in Casadega?
Oh, hold on.
Because we're making a lot of comparisons to, this is their,
Well,
this is their
regardless of the height of the tower,
agreement, but,
right, regardless of the height of the tower, these are sound standards, right? So,
I know, but the basis of our decisions, a lot of them are based upon the fact that we're gonna have 600-foot towers, so
yes.
I'm just wondering what kind of comparison we can make to them.
Well, I guess what I'm
without
saying
knowing
is
what
that
the height of their towers are.
even if a much larger tower were being proposed, we'd still be held to the standards, the sound standards being discussed separately, right?
Yes.
So whether it was a 100-foot tall tower or 600-foot tall tower.
And flicker.
Same
And flicker.
Same flicker, and decommissioning and so setbacks, that's why setbacks are discussed as a relative to tip height.
Right now, the Berry zoning is 500-foot limit, right, at towers? So you may want to retract that, we're gonna have 600. You're jumping the gun.
No, I am, you're right. But what, the point I'm trying to make is,
That's what we are gonna be talking
if
about.
we're making comparisons here to what a 600-foot wind farm
Yeah,
would have, what effects it would have, and we're comparing it to Casadega.
right,
There's apples to apples. Right.
but I was wanting to backtrack.
Yeah, understood.
We're not.
No,
So we do not know how tall the towers are.
I'm just,
At Casadega, I don't know what model they settled on. I have their,
What's the name of the wind farm?
Casadega.
It's Casadega, that's the name of, well, because you give clever names to a lot of the projects, that's why I'm wondering what Casadega was. If it
Or
was
there's a town called Casadega.
It's Casadega Wind Project, is that
Casadega.
correct? Okay.
Casadega Wind LLC. Well, that's,
Under the towers at Casadega Wind Project, Casadega.
one of the other things that Apex, we talked about this last time, was the proposed change to the underground lines and the guy wires, because there are, the current zoning talks about the ability to have some overhead lines, and guy wires are allowed. you're proposing. Can you tell us about that change a little bit?
Me, yeah, well, we're, Department of Ag Markets, who sits on the Senate board, is gonna require us to bury collection line between turbines, depth 4 feet wherever possible, and to justify instances where that is not possible in our application. I believe, I have to find the clause here, but what we're proposing is an amendment that allows us at the site of the substation to have a structure with guy wires that connects the substation to the existing power grid. That's what we're concerned about. And to allow for, you know, that conversation between us and Ag Markets in the Article 10 litigation to play out.
I have the height for the Cassadaga project. So it's 114, blade diameter of 114 meters and tower height of 100 meters. So I took the radius of the blade diameter, which would be 57, and the 100-meter tower height, and converted that, so we're talking 515 feet. So about 85 feet lower than what is proposed for our project.
Well, the ones they want to put here is 642, correct?
That's incorrect, 591. We're proposing a tip height of 600 feet to allow for the newest generation of turbines.
Okay.
Can I ask just a quick question? Is that like set, or could that change still?
We're proposing 600 feet, so if we were to need to change it again, we have to go back to this process.
That's checking.
So the proposed changes that Clear Skies is going to provide the board won't be here until sometime around November 1st, is that correct?
Yeah, I mean, we're trying to go through it and trying to make sure that any suggestions that we have changed aren't just like, oh, we're, just pulling them out of the wind, but that have substantial, like, this is why we're
Substantial
proposing.
reasons.
Yeah, we're gonna try and substantiate everything that we're trying to, change. We had kind of put it on the back burner, and so now we're frantically working to try and get it done and be as thorough as we can, before presenting it to you, and make sure that it has, everything that it should have in it.
To that point, the board did set a deadline, right? November 1st, end of day November 1st? Gotcha, just wanted to make sure I understood that.
Then November 1st for submission.
Yes.
So still we have time to discuss it.
Yeah, we're hoping for December or January 1st recommendation. It's our goal.
To go on.
Carrie, can I ask you a question?
Yeah.
When you guys do yours, are you gonna have like an overlay of what,
The way
of what this will look like with the proposals? Because we get caught up in the sound things, and I'm just doing quick calculations, and I don't have a map in front of me, but I'm pretty sure
Yeah,
I
so
can figure out the answer.
the way that I'm, gonna try and go through and do this is that I actually have, taken the whole wind ordinance, and I have it on a Google document, and I have in there like highlighted where I'm getting the information from, so like there are some areas that I'm looking at other towns and what they have, and rather than nitpicking and going through and saying, I'm gonna change this word and this word, we're just gonna take, delete this section, insert this section, that type of edits, and everything will be,
Footnote of where you get it from.
organized, yeah, and so I can, plan is to send it electronically, so I don't know, you can use your phones, because it will be the entire wind ordinance. And hopefully if you have other ways though that you would like it, looked at, that's the plan. And there's sections that I don't, as of right now, don't have any changes, and it'll just say no change, and
Yes, electronically is good. We need
Okay.
at least one.
Hard copy. Okay.
I got a question for Ben. What we've gone over tonight so far, what's that do to the project?
Well, you know, anything more restrictive than what's applied at Casadega, we would consider unreasonably burdensome based on the fact that it was all mitigated, you know, using the most recent studies and standards available, except for the WHO thing, which was just released this last couple months. Increasing setback standards against homes, you know, practically speaking, would largely eliminate, you know, it will eliminate buildable area variance. So have to increase setback standards. So depending on how much a setback was increased, you lose buildable area for turbines, and turbine project is smaller, and at a certain point becomes uneconomical to the developer.
I gotta admit, I
I
have
think
no
Carrie
concern.
Carrie,
Carrie
Carrie.
had her hand up.
That question kills my heart, because as a resident of the town of Berry, I'm hoping that the entire planning board is looking out for the welfare and well-being and protecting the safety, and the idea of looking at it as, we can't make too many changes because we're gonna kill the project, instead of looking at it, are we doing the best that we can for the citizens of Berry?
As a leaseholder, Kirk, you shouldn't have asked that question.
It's in the
Being a member of the planning board.
Well, I think.
Well, let Carrie finish.
And I just think that, you know, when we're, as planning board members, it really is, you know, it's hard to negotiate when we were buying our house. Jim Salmon said to me, because as we were going through, I'm like, I just love this house. And he's like, Carrie, if you're not willing to walk away, you can't negotiate. You can't, if you're saying that you have to have this project or you have to have this house, and that's what I was saying, he's like, you're not gonna be able to negotiate. So if you wanna negotiate the price, you have to accept the fact that you may have to walk away from this, that it may not be the best option for you, or for your future family. And so when we're going through this, it should not be, if this decision, by making this decision, are we killing the project? And I'm telling you, that's not how we're going about developing. That's why I'm gonna have substantiation of, this is why we feel this way. We're literally looking at it just to protect the citizens and the residents in our community. We're not looking at it as, oh, if we, let's look at the map, and if we set this up, we're not being vindictive about it. We're not trying to say, oh, you know, we're gonna push this project. No, we are, and what we propose will be what we feel, you know, as a group. Ideally, honestly, I didn't want just our group. That's why I didn't want just our group to do it. That's why I wanted a committee to look at it and to say with multiples, because yeah, well, I'm not gonna lie, when we had our committee get together, 10 times the tip height was the discussed setback, and that's what we wanted. Well, none of us are leaseholders, none of us are, you know, and so maybe that's a little bit excessive. So we had to go back and look and say, okay, let's find information. Is that too much? Is that not enough? And to go through and do the research. So I'm sharing with you that at Clear Skies Above Berry, we are not going to be proposing things that just for the sole purpose of trying to get rid of the project. We are proposing changes that we feel are going to protect all, and again, I'm saying all, I'm not saying just the people who are non-participants, all of the residents of Berry.
And should, Alice Mathis wrote, and should all the residents of Berry follow the laws and apply their zoning and have their permits and have their variances and things in order? Or does that just apply to some people, not everyone? Here's my question.
I think that goes into a red line of, you know, a tit for tat, and I think that gets ugly fast.
Chris Moss, Root Road. I think you can go overboard too with your safety. And you can just, carry it too far. What are you protecting people from? Every single incidence of something or a percentage of something? You're trying to eliminate every possible thing.
That's
Well,
critical
and we
thinking.
can't,
That's-
we haven't
You have to
proposed
be
any.
reasonable about that.
Yep.
Yeah.
One at a time. Go ahead, John.
I just want to point out, the questions and answers should be with the board members.
Yeah,
not-
they should not be amongst the,
Yes.
please direct your questions to the board.
I have another article here for you, since we're talking about the project, if I can speak for 2 seconds.
Yes.
This is from a group called Wind Power, and it's an article that states, Apex Clean Energy Review could lead to sale. United States, Apex Clean Energy, one of the U.S.'s largest wind developers, is currently undergoing strategic review that could lead to the sale of the company. And I'll give you the article, but I need a copy of it as well. And Mr. Yasmin was asked several times in regard about that, and he said he didn't know anything about it, but there it is. And that's for the leaseholders and everybody. I mean, we're all in the same boat here in the town.
Okay. Those three go
I
together.
need to get copies of all 3 of those documents before we leave tonight.
So I guess, are there other things we need to consider with this alternative proposal from the group? Anything else we want to go over?
There wasn't one on here that I just noticed that was on the signage, no advertisements on the WEC structures. Is that normal?
I don't know, we don't put it, we don't put signage on it.
Yeah, well,
They're not billboards. so-
They're only asking that if there is, it's, a contact sign should be put on the tower, surrounding fence or whatever, 2 by 2, no, actually 2 square feet with a contact information on it.
Like
Like
the,
emergency contact
Yeah.
information like that. But they were asking for there not to be any advertisements on the WEX for
no,
business.
no.
Yeah.
No, I mean, they're placed in the back of cornfields, so I don't know who we'd be advertising to.
We talk about insurance coverage. Or, I think didn't Lance talk about that last month? 2 weeks ago?
I don't know what we're current.
Or if it's even in the,
Yeah, I'm not sure where it is. Do you recall, Ben, if there's insurance changes being?
I don't recall discussing that last time. If you have specific questions.
350-107B, insurance liability, I think it's already.
Because our current zoning says it's required to have a issuance of a building permit. It doesn't identify a limit. Liability insurance of a reasonable level as determined by the town board in conjunction with the town's insurer. Did they propose a limit?
I just wanted to-
Was that gonna be, Carrie, was that gonna be something that you were going to address? or not?
No, honestly, unless somebody else from the committee, brings it up, or brings up a concern with it, that wasn't on my list.
Okay.
Yeah, what we have in ours meets what they're asking for. I didn't get that far.
Okay.
No. I'm just about waiting for word.
One of the things too that this talks about, the group's changes, talk about a defect ban. And I'm not educated on what that is, but I'd like to know what it is. Did you see that?
I did.
It's in that letter.
De
facto ban, it's the term used in the proposal.
So defective zone is the, defective zone is the radius around the commercial wind turbine. Upon information, and this is, I'm quoting this from the group's proposal. Upon information and belief, industrial wind turbine manufacturers recommend a minimum setback safety zone of 3 times the turbine height. So proposed is, would be 1,800 if, at Apex proposal. In this case, 1,500 feet between any home and industrial wind turbine for safety purposes in case of catastrophic failure of one or more components not to protect against adverse effect resulting from noise. As a result, industrial wind turbines by their own safety standards create de facto ban no-build zone within 1,500 feet radius surrounding the turbine. In many instances, this no-build zone overlaps within the property owners who have no agreement with the wind company. To protect non-leased landowners' rights, a de facto ban is required within Barry's wind laws. This de facto ban protects non-leased landowners' rights to use and enjoy their property. It would require the wind company to obtain an easement from the landowner. So that's one of the things that this proposal has in it, which is not wording that we currently have in our zoning. That's something that's totally new. They also have a right-of-way easement ban that they're talking about, which is
Easement for the landowner, yeah.
right-of-way easement ban disallow the wind company to install underground cables, collector systems, or overhead transmission lines connected to wind turbines to substations and ultimately to the power grid. So the right-of-way easement ban would put a lot of different restrictions on the wind energy company.
The premise that a wind developer may seek to secure land rights that do not necessarily require a lease or purchase of land, I don't agree with. We're only developing this property on leased ground, that's under contract. So we have no right to eminent domain, I think we talked about that.
Yeah.
the last meeting.
Do any of those apply?
So that's their proposal. They're proposing those things, that we modify our zoning to include a right-of-way easement ban.
Oh, okay. But if you're not gonna do them to the other land, not lease.
So the right-of-way,
Also saying overhead lines and everything else. Can you read that one? Further.
the last sentence says, the right-of-way easement ban will prevent the town of Berry and the state of New York from dispensing right-of-way easement permits for the construction and operation of a wind facility. So. We don't have any wording in our current zoning that's even close to that.
Yeah, we'll discuss it.
I guess we should give, well, you're gonna provide your proposal, and then we'll get Lance here and do the same process.
If there was some, not sure what they were asking in their proposals, or if there was some confusion, do you guys have to go back and contact the letter writers, or you just kind of to get clarification?
I don't know what they do ask us to confirm that we've received a letter and discussed it.
Well, we could ask any one of the 7 or 8 people that signed that, what they meant by it and what they're asking of it.
Yeah, my letter's from John, he's here tonight, so.
And you guys supposed to respond to
Well, the question was whether or not we're going to ask any of the individuals who supplied these letters to the board, any clarification on the topics.
I would think that's what this meeting is for.
We did go through,
I mean, if you wanted to.
we did go through and summarize the issues and try to get them in terms that were equal to what we have. Or not equal, but comparative.
Right, but there was some things I just really didn't understand what they were trying to present. We need clarification from.
Yeah, we do need it because it's the way that they presented it to us, it's kind of, yeah, we have to,
it. Major concerns are always the same, it's setbacks, noise, and the environment. And those are quite clear in that document. They're easy to find and they're explainable to a third grader to do.
It sounds like those are the three things that,
They're universal.
wow. Guess we're not third graders, huh?
You know, the health and well-being of the citizens, health and well-being of the animals and the environment as well. And that plays a big part in quality of life and quality of life for our town and the residents that live here.
There's just so much here, John, so much. What's the most important for you for us to work on?
That's
So
what I just,
setback and noise.
yes, and it always comes down to that.
Okay.
To that, the rest is The rest is, I don't know how to explain it, but what we had done was we looked at a lot of other wind ordinances across the state and what they had proposed. And part of that came from those other wind ordinances, because we don't have the benefit of a legal team and, you know, the resources of, you know what I mean, 100 people sitting there at the computer all day long. We did the best we could to protect our town and the people that live here, all the people that live here. And that's why, you know, that's why I keep delivering documents to you guys, and that's why I was concerned about the possibility of the sale of Apex before the project was even done. And that's a concern to everybody that's holding a lease, I would think, right now. And I'll be honest, Mr. Yasmin's been asked several times if that was a possibility, and he denies having any knowledge of that possible transaction. Whether he knows or not, I don't know. But like I said, my concern always comes in. You guys know me, you know my concerns are always my town and the people that in the animals that live here. That's it. It's quite simple.
Thanks, John. Carrie, you have one last?
I was just gonna share too, that clear skies above Berry, so any, like, our proposed changes to the wind ordinances and stuff, we cannot and we will not use any intervenor funding for that. So like, as we're going through, that's residents of Berry that are reviewing and trying to go through and figure out, things, and then, we are, the residents of the group and the money that we have raised through donations, we are having our attorney review it before we submit it to you. So, you know, so he can make sure that everything is in line as well. But I just want to share that just because I know a lot of the times people think, well, oh, they got intervenor funding and, you know, so that's what, no, that's not what intervenor funding is for, and we will not be using it for this.
One last thing, George, I have a legitimate question. I don't feel you need to scold me for that. We haven't scolded you for asking any questions. Everybody here wants to know what it does to the project, and that's legitimate. You
Let's
just
be honest
stay
about
on.
it, wait a minute, let's be honest about everything. From the start to right now,
You've
where
already
we are,
spoken.
you've done nothing but help Apex win out.
John, we're not gonna turn into a shouting match here.
Right, I can answer Kirk's question.
Kirk asked this question to John, let him answer it.
No, it wasn't a question, it was
he's
a
attacking.
comment that you didn't like me asking that question, George, and I wanted to know.
But can I answer?
Yeah.
Okay.
Okay,
So I'll answer why. All right. There's a conflict of interest with the servant on the board. You know that. You're supposed to, you can't vote on it.
correct.
And not supposed to, in my opinion, not supposed to discuss it with it. You can listen, but you're
That's
not
your
supposed to
opinion.
discuss. So
I-
that's, okay.
Stop right here.
All right,
That's your opinion.
all right.
This is another warning for the farmers out there that signed leases. This came from a farmer who has done so and regrets it. And they didn't honor their setback, well, they didn't honor their, and I don't think it's Apex, but they didn't honor the easements, they didn't honor and half of the contract that he signed with them. And
Okay.
I don't know what you do with them, you gotta have money to sue them. Just read his, and you can make copies for everybody that signed the lease if you want, and they can share the loss.
Okay. Just to make it known again, we did ask Lance for a determination on that topic, and we talked about whether or not the two members on the board who have the wind leases can participate in the discussions and whether they can participate in the voting, and it was provided in a letter from Lance that discussions could be had. They could remain on the board to discuss these topics, but not vote on these issues.
Just as a resident though, you know, anyone who's serving, and I do want to share with all of you, I truly do appreciate, because this takes a lot of time, and it takes a lot of extra that you don't have to be doing this, and you're doing this for our community, and so I would like to say thank you for that. But when it comes to decision-making, and I know that you're not voting on it and you're just making a recommendation to our town board, but I also know how highly our town board regards your recommendation and how highly, they will, that it's not just recommendation. Unless they have very serious concerns, it's probably going to be, majority of the time, going to be the way that they go. And so as a resident, it is.
The obligations, the ethics, and the things that are, the 5 steps that, to success as a board member. And, we've talked about it many times on here, and we keep trying to reiterate these things that, hopefully the members on the board are not focused and geared toward one topic, that they're looking out for all the topics.
Right.
And they're discussing things equally amongst everyone, so.
And, yeah, and I mean, I would never call for someone just to, because they feel one way on a particular topic, that they either are not allowed on, or that they are not able to serve, because we all have those different things that we have, have different biases or interests. But when it comes to finances, and when it comes to, there are times where it is appropriate to say, this is something that I can't discuss because I have a bias, or have a very, a financial, I'm financially incentivized and therefore need to refrain.
Oh, yep.
Robin Nanga. I can't talk specifically about the windmill, so this is just a conflict of interest, not presenting what I'm saying. I know that you keep going back to your book, and there's federal and state laws that are superseding what maybe that concise area is. And if you come to the meeting on the 30th at the library, you'll get the laws in full. And it does say that regardless whether it be windmills, water, electric, whatever it would be, that board members are not supposed to take part in the conversation or be an advocate for one side or the other. They're supposed to refrain. So I don't know why our attorney keeps saying that it's okay, but I suggest that you get these laws off the internet or have your attorney get them for you, because I did give some to Mr. Pope quite a while ago and gave him a whole set. So you should really look at them and see whether or not there is a conflict. Not just criminal, because I'm not into that. I'm talking about conflict of interest and what a person can do in a public office. I was quite enlightened when I started reading them, even though I worked with a lot of attorneys. I didn't realize they were so complex. Thank you.
So I need to, I'd like to make a motion that the board go into executive session at this time.